I guess y'all wondering why I called this meeting. No. Well, thank you guys so much for coming up to see us. We have really enjoyed having you guys here in D.C. We want to do before you guys leave, but we're going to go ice skating. Not done skating before, so they had a little challenge getting used to it. Kept trying to help them along, and then I would find that they were just basically, you know, relying on me completely. So I had to sort of like say, okay, why don't you try this on your own?
Hey everyone, it's Katie from Without a Crystal Ball. Welcome back to my channel. The judge has ruled in Josh Duggar's case, and y'all, he just called his frivolous. He just called Josh Duggar frivolous. Legitimately called Josh Duggar frivolous. Remember how I told you that Mr. Judge Brooks seemed to be irritated with Josh? Yeah, it's clear he's irritated with Josh, especially in his order that he just wrote to the court following his hearing from 2 weeks ago. So remember how I told you that there was going to be a formal order written by the court? Well, he's done with that. And he goes through point by point what he did in the courtroom and what he said in the courtroom. And this was addressing the motions 36, 38, 39, and 40. I don't know what's happening with motion 37, to be honest. I don't know what they're doing with that motion, and I don't know when they're going to actually be covering that motion, but all of the motions for this one were denied. And the judge says that even if it's what he says in this order would supersede anything he said at the bench. When it comes to the motion where they said that Josh Duggar didn't get to speak to his attorney because the agent took his phone from him and denied his right to counsel, they say that that's just not even true, because Agent Faulkner told Mr. Duggar that he was free to leave and he could contact his attorney at a later time. So the judge says this: at that point, Duggar pulled out his iPhone from his pocket and stated he would like to contact his attorney. DHS Special Agent Faulkner testified at the motion hearing that he took Mr. Duggar's phone from his hand, and before he could call his attorney, explained to him that the iPhone was covered in the search warrant and he would be seized. He then told Duggar that he would have an opportunity to contact his attorney later and that he was not under arrest, so he could leave the premise if he liked. Interesting how they left that part out, right? They said that Gerald Faulkner's testimony was credible. So after spending all that time trying to downplay and say that he was a lying McLyerson, Judge Brooks said not so much. In regards to Josh being forcefully taken into the car, the judge says, yeah, right. The judge explained that the two agents with credible testimony showed that Josh Duggar, by his own accord, walked into a car, sat down himself, the car wasn't locked, he opened the door himself, and he sat down himself, and he was able to leave at any time. He also says that they found any evidence that their questioning was aggressive, or that they were outside of their bounds, or even that he was denied counsel, or that they ignored his want for counsel. He shared a portion of the interview as sort of an understanding that Mr. Duggar understood his rights. And it said, sure, it says here, only for now, it's for any other. Agent Aycock says, sure, like it says, if you decide to answer questions now, you still have a right to stop. This is saying, and Mr. Duggar interrupted, and it says, this is USCIA, and the agent Aycock says, this is U.S. Immigration and Customs Enforcement, Homeland Investigations. So you've signed that you understand your rights. Mr. Duggar says, yes. He says, so now that what I'm going to ask you, are you willing to speak to us without your attorney present? And he says, Mr. Duggar says, I may not answer everything, I guess, but yes, I have more questions than, and it says, sure. So the time is 15:40 on 11/8/2019. So you're going to, right now for the waiver, is that you're just going to print your name and sign, and that's all that you're saying is acknowledging what you wanted to do, speak with us. And Mr. Duggar asked, I'm in custody, and he says, no, as we explained, this is a search warrant. And he said, okay. So he scratched out that he was in custody, and he signed the form. And he says that in the motion, Mr. Duggar contended that he invoked his right to counsel when his iPhone was seized, and that agents should not have approached him later seeking a waiver of his Miranda rights. when he had already requested counsel. But they say that the problem is that you can't invoke your rights to an attorney on the anticipation that you might go into custody. So you can't invoke your right to an attorney until you're in custody. And because he wasn't in custody, you can't invoke your rights, according to the judge. He said, at this time, Mr. Duggar was free to leave the premises, but he chose not to do so. And although he points out that he did not have a vehicle at his disposal and could not drive away, he was perfectly capable of leaving on foot. And it also goes through whether or not he was in custody. And he says that they have to determine whether the suspect was informed that he was free to leave, which he was, and that he was not under arrest, which he was, whether the suspect possessed unrestrained freedom of movement during questioning, which he did, whether the suspect initiated contact with authorities or voluntarily acquiesced to official requests to respond to questions, which Josh did, whether police used strong arm tactics or deceptive strategies during questioning, which he says did not happen, whether the atmosphere of questioning was police dominated, and whether the suspect was arrested at the end of questioning, which none of that happened. So he argues that Gerald Faulkner told him that he could leave. Gerald Faulkner told him that he was not under arrest. He had undisputed freedom of movement, even when he was in Mr. Aycock's vehicle, because the doors were not locked. Regarding the questioning, Mr. Duggar was free to refuse to answer questions, and he was able to stop at any time if he chose to. The tone of the interview was conversational. Remember, they actually listened to it in court, and it was not heated. And he said Mr. Duggar did sign a form demonstrating he understood he was waiving his rights to counsel, but he also manifested a clear understanding of the waiver and voluntariness of his actions by reminding the agents before questions began that he may not answer everything. So it was not adversarial in nature. He also said there's no evidence that they used any strong arm tactics during the questioning, and it doesn't find that the interview was unnecessarily prolonged. He says that Mr. Duggar points out at times during the interview that the agents interrupted him. The court reviewed the transcript with the audio recording played during the hearing and concludes that the participants were talking over or into each other. The court does not believe the agents were attempting to silence or intimidate Mr. Duggar. Rather, the interruptions appear to be innocuous features of the back and forth conversation between Mr. Duggar and the agents. An example they gave was Mr. Duggar initially refused to answer, stating, "I'd rather not get into specifics or knowledge on the BitTorrent." And then the agent responded that he understood and that Mr. Duggar was probably not going to answer any more of their questions on those topics. That was an example of being interrupted. And Mr. Duggar agreed and said he wouldn't do so without any counsel, acknowledging that there were some questions he didn't want to answer without counsel. So the exchange went like this. Right, I don't want you to think that we're keeping you from having an attorney. I know when we got here. Right, Mr. Duggar says. Agent Faulkner said, "You said you wanted to call him." And Mr. Duggar says, "Right." And he said, "Obviously, with your phone, we can't do that. We will call him, and he can't come to the scene right now while we're here, but we will be at least able to alert him of the fact that we're here." He contends that Mr. Faulkner stated that counsel could not come on scene and that this was a deceptive tactic designed by law enforcement to trick him into believing that he was required to continue answering questions and could not invoke his right to counsel. The problem with Mr. Duggar's argument is that the recording of the interview tells a different story. Agent Faulkner made the statement about Mr. Duggar's attorney. Mr. Duggar continued to answer and declined to answer questions. At one point he stated, I can get in touch with my attorney to see what he says." At another point, he refused to give the agents the PIN numbers to his phone without talking to his attorney. And then he explained, "If the attorney says go ahead, then I'll say sure." And he says it's clear to the court that Mr. Duggar understood the scope of his waiver and that no Miranda violation was committed. So he was free to answer some questions, but then another says, "Well, I'm not going to answer that until I have my attorney." It's funny how his motions mentions none of this, isn't it? So they basically say that even if Agent Faulkner didn't reach out to his attorney, even if he was being slightly deceptive, they say that it's maybe a strategy, but Mr. Duggar didn't fall for it. And therefore, that factor weighs in the evidence of it goes in the favor of the government. And then the final factor that they were supposed to consider was if the atmosphere was police dominated. And they said that there was no weapons drawn. There were a bunch of people there with tactical gear on, and only 2 of them approached him with a search warrant. No weapons were drawn. No one was placed in handcuffs. And he and his employees were told they were free to leave. In other words, it was painted, the scene painted here is standard fare for the execution of a federal search warrant. Nevertheless, the whole atmosphere was police dominated, and this factor weighs slightly in the favor of Duggar. Sixth, and finally, Duggar was not arrested at the end of questioning. Therefore, this factor also weighs in the government's favor. So he says, considering all 6 factors, he was not in custody. He was told he was not under arrest when he arrived at the police agent, he was told he was not under arrest. It says he requested counsel at the time of his cell phone was seized, but he was not in custody then, and he was not in custody later when he submitted to police questioning. Further, the fact that he was given Miranda warnings or asked to sign a form confirming he understood his warnings is not determinative that he was in custody. And giving a Miranda warning does not in and of itself convert to otherwise non-custodial interviews in custodial interrogation. So basically what he says is he was never in custody, which I told you guys he wasn't. The protections under Miranda never attached to him. Denied. So the hands and feet. This one is kind of interesting. So when it comes to the hands and feet, it's pretty simple. Josh gets taken into the setting, and he says that after he is processed, Agent Faulkner happens to see that Josh, who is sitting kind of in front of him, he noticed a scar on his hand. Faulkner notices a scar, and he tells Aycock, hey, I noticed a scar. And so he wants to take a photo of it. So he informs Aycock, and then Aycock says to Duggar, hey, would it be okay if we took a picture of your hands? And he says Mr. Duggar consented, and he was directed to just place his hands on the flat of a table. And then he picked up a cell phone and leaned over the table so that his camera was positioned above his hands. So basically, Josh was sitting down, the agent was standing up over Josh, Josh was already seated, and he just took a picture of the hands. He says Mr. Duggar argues that the government needed a warrant to photograph his hands and violated his Fourth Amendment rights. He also argues that they're obligated whether he wanted to consult with his counsel before he consented to the photographs. He says there's no legal authority to suggest that a warrant would be needed for the hands and feet. They say that fingerprints would be more intrusive than taking a photograph of a hand because you're not actually touching the hands. And they also said even if a warrant were required in his situation, it's black letter law that a warrantless search is valid if conducted pursuant to knowing and voluntary consent of the person subject to the search. So he consented, and so there was no violation. Even if they would have needed one, he says, there's no violation because he said yes. And then in terms of the Sixth Amendment and doing this outside of the presence of counsel, he says that that's regarding incriminating statements. And that's from an accused after he's been indicted. But he says booking records, including fingerprints and photographs, are not considered testimonial statements, nor is booking process considered a critical stage of prosecution. And it says that for those reasons, this is denied. So he wasn't in custody, and booking and fingerprints and photos are not considered critical aspects of a case. Got it? I knew that one was going to get denied. Now, this is the most hilarious one. Violations of the Appointments Clause. Remember, it's Donald Trump's problem, and it's his fault. So it says, he reasons that because Secretary Wolf's appointment to head the agency is deficient in some way, the entire criminal investigation into Mr. Duggar's contact was undertaken in violations of the Appointment Clause. The indictment must be dismissed. The judge doesn't even go into arguing. He just says, this motion is frivolous. There's no legal support for Mr. Duggar's claim that an indictment handed down by properly impaneled grand jury would be subject to dismissal due to an alleged Appointment Clause violation. Department of Homeland Security agents are sworn to enforce federal crime statutes, and the court is not aware of any reason why their authority to investigate crimes would somehow be undermined if the acting secretary of their agency were improperly appointed. Told you guys, the guy up in Washington has nothing to do with the guys that are sworn in to do the criminal investigations. They're not connected. And it says all cases Mr. Duggar cites in the support for his motion were civil immigration cases involving direct policy-making or rule-making authority of the acting secretary. These cases are in opposite to Mr. Duggar's, an indictment returned by a legally constituted unbiased grand jury. And he says, this is denied. That was my favorite one. My favorite one was that it was a frivolous motion. Now, The motion to dismiss for failure to preserve exculpatory evidence. He says that his final motion, he complains that the federal agents failed to preserve exculpatory evidence because he did not perform forensic analysis of electronic devices possessed by certain key witnesses. He points out that the agents waited about 5 weeks after searching his business to start interviewing potential witnesses, and then finally searched their phones and failed to preserve evidence. They said that Mr. Faulkner, Agent Faulkner, confirmed during the motion hearing that the witnesses were interviewed and their cell phones manually searched for evidence of CP, and no CP was discovered. He asserts that for that reason, the cell phones were not forensically searched and inventoried or imaged. Basically, what the judge says is that failure to preserve evidence does not constitute a denial of due process unless law enforcement acts in bad faith, and that the evidence had apparent exculpatory value and comparable exculpatory evidence was not reasonably available to the defendant. So they say basically what the judge argues is that for evidence to have constitutional materiality, it must possess an exculpatory value that was apparent before the evidence was destroyed, or in the instant case before agents failed to preserve the lack of evidence on the witness's cell phone. That's funny, the lack of evidence. He called it literally the lack of evidence. Mr. Duggar's evidence of the government's bad faith is found in the affidavit attached to the search warrant signed by Agent Faulkner. The affidavit claims that performing a forensic review of electronic devices is critical to law enforcement's determination of whether a crime occurred. Mr. Duggar observes that even though law enforcement understood that it was important to forensically review the devices here, they only imaged Mr. Duggar's electronic devices and decided against imaging everyone else's. He says that the court finds that the law enforcement's decision not to forensically search and image certain electronic devices was made pursuant to a good faith belief that such additional investigative steps were unnecessary. Valid reasons may exist to criticize law enforcement's thoroughness or lack thereof on cross-examination, but the court is simply not persuaded that law enforcement's action rise to a level of a constitution deprivation of due process that would require dismissal of the indictment. So that's denied. So therefore, it's ordered that all motions are denied. Motion to suppress made by Duggar, motion to suppress hands and feet, motion to dismiss indictment on the appointments clause, motion to dismiss the government's failure to preserve as potentially exculpatory evidence. So the judge flat out said, that's frivolous, your Constitution rights, you were not violated. Josh, you were not in custody. You were free to leave at any time. And Josh, you're a big boy. You knew when you were being interviewed what you should say and what you shouldn't say. But your attorneys left that very much out of your motion. That's odd, right? And your hands and feet don't require a warrant. So the appointments clause was frivolous. I told you it was frivolous. I felt like it was frivolous, but it's pretty evident based on how the judge really is. This is really straightforward. It's like they just made arguments out of nothing. He tried to find faults in the investigators where there were none. And because he didn't agree with something, basically what the judge said is just because you don't agree and you criticize how they handled things, we can't just waive that or get rid of the whole case. But you could ask and criticize during cross-examination and let the jury decide what they think. And they might agree. Reasonable doubt, right? But not worthy of the indictment being thrown out. Now, in regards to Motion 37, I don't know what's going on. I don't know if they're going to rule on it. I don't know if the judge is still mulling it over. I don't know if it got withdrawn. It's still open. So Motion 37 is still outstanding. That's about the warrant. Based on how everything else has been ruled, though, I have a really hard time believing that they're going to withdraw this motion, the warrant. It would be impossible, honestly, to be honest. So I expect 37 to be denied. I just don't know when. So that's what we have for now. Josh, your frivolous motions are overruled and denied by the court. We'll see you at your scheduled trial in November. Or, Josh, you can decide to take a plea deal and take less years and stop wasting your money. What are your thoughts about this? Tell me in the comments below. Bye, guys.